there's very few hotter button topics than kiddie porn. It is something that I would hope is universally not only condemned, but contemptible. I mean, truly contemptible. Hello and welcome to the next episode of Beneath the Law. I'm Gavin Tighe here with Stephen Thiele. Stephen, how are you on this fine evening?
Oh, I'm doing good, my friend. A little bit chilly here. The snow has come to Toronto.
Yeah, it's the winter wonderland. We went from the boys of summer to the Frosty the Snowman within a week. As our poor Blue Jays got as close as you could get. I don't think in the history of sport, Game 7, extra innings, man, boy, talk about the brink of joy to the agony of defeat.
I don't know. I was at most of those games, and I must tell you that I actually couldn't stay to watch the extra innings from my seat. I had to basically get out of the seat and walk around the stadium because I was so nervous watching the play, and I could not believe that I guess some base running errors will be the continue to be the talk of the Jays losing versus winning, but that's the way it is.
It's one of these things you've heard us talk on this podcast before, and I know it's sort of a old saw of mine. Probably a lot of people are sick of hearing it, but the charter has a thing called the notwithstanding clause in it, which is getting a lot of attention these days. Sorry, I'm losing my headphones. Getting a lot of attention these days from a lot of quarters, Alberta teachers, Ontario bike lanes, you name it. But we used to be a third rail in terms of politics, in the sense that no one ever wanted to go near it because it was, oh my goodness, you don't want to be seen as the government that breaches it. But certain cases are making it palatable to the public and almost acceptable. And in some quarters, the public is crying out for it. And it's cases like this case that recently came out of the Supreme Court of Canada, which I think to a large degree has been misportrayed in the media, but it really doesn't matter. But as a political platform, really give politicians a point to jump off in terms of the use of the notwithstanding clause. And frankly, my own view is I think that if the notwithstanding clause becomes too acceptable, we won't have a charter at all. It just becomes a glorified Bill of Rights because you can notwithstand yourself right out of it.
Well, look, I mean, I think we're going to see that come up in a couple of decisions. You talked about the Alberta teachers case. There's the religious secularization case that is going to the Supreme Court of Canada. There is the pronoun case from Saskatchewan that has been granted leave to appeal. We will see what guardrails the Supreme Court of Canada decides to put on Section 33 and the notwithstanding clause, because the charter was a contract between the provinces and the federal government, and in order for Pierre Trudeau, Prime Minister Pierre Trudeau, to have his vision of the Constitution when it was repatriated, to have a charter of rights and freedoms, he had to make a compromise. And that compromise is worded, in my opinion, very clear that a province or any government can invoke Section 33 for a period of 5 years and make the legislation immune from charter challenge. So it'll be interesting to see what the Supreme Court of Canada does. This case sparked outrage, right?
Yeah, I did. I mean, I think, look, there's very few hotter button topics than kiddie porn. It is something that I would hope is universally not only condemned, but contemptible. I mean, truly contemptible, and a horrific crime against, frankly, the most helpless and innocent members of society. And if the law is there for any reason, theoretically, it is there to protect the innocent and the helpless. And these are the most innocent, the most helpless. So, the case, it was a case called Seville and Naud, and what it related to, and this is what's really kind of horrific. It didn't come out in the media very much. And one of the things we talked about before we started recording the podcast today was just really what happened to these guys. What was the sentence? So, just to give this a bit of a background, there is certain sections in the criminal code that take the discretion, if I can call it that, away from the sentencing judge, who is given the verdict, or either in a judge alone or jury trial. They're given a verdict, and then the question of sentencing goes to the judge, and the judge makes a decision what's a reasonable sentence or not. Now, in some instances, the legislature has put forward what they call mandatory minimum sentences, which is say you can punish this perpetrator with more time, but this is the minimum that they get for this particular crime. And in the instance of child pornography, the minimum sentence set out in the criminal code was 1 year in prison. Now, I think a lot of people would think that's it.
Right. That's pretty low.
But apparently no. Apparently no. The issue here, in first instance, so this is what's really pretty horrific as far as I'm concerned. So the facts of this case are, I think are quite jarring, and it really have not received, as far as I know, a lot of the mainstream media of attention. There's been a lot of attention paid on, the Supreme Court struck down the Section 1, and we're going to get there in a second. It's my long-winded roundabout way. But the charges related in the case of Mr. Seville, that he had 475 child pornographic files in his possession, 317 of which were young girls between the ages of 3 and 6 years old, subjected to various sex acts by adults. Mr. Naud, he had 531 image and 274 videos of child porn, kids between the ages of 5 to 10 who were victims of child abuse, sex, and sexual acts. I mean, this is horrific stuff. It is truly awful, because, in order for that material to exist, some poor child had to have been completely victimized in the most horrible fashion, and scarred for life. Frankly,
they're scarred for life.
That child will never be the same. That child will probably perpetrate, or I'm not saying they will, but I mean, there's lots of studies that indicate that victims of that have their own issues as they get older, and probably understandably. But this is a horrific crime. Now, as I understand matters, the way we got there was that in the court of first instance, both perpetrators, the judges said, well, I think a year is too much for these fine gentlemen, and I'm going to give them less time. I think one gentleman got 90 days to be served intermittently, which means you can go to jail on the weekend. 90 days probably, and I think the facilities that take care of sex offenders of this nature are not your penitentiary type facilities. Obviously, they are segregated facilities. I mean, child pornographers don't last long in the general population in prison, so there's special facilities for them, etc. So that was, the judges of first instance gave them significantly less than the mandatory minimums. That went to appeal. The Court of Appeal said, no, sorry, but there's a mandatory minimum. They get a year. And that case went to the Supreme Court of Canada. And it's the Supreme Court of Canada ultimately struck down the section of the code that required the mandatory minimum sentences as being unconstitutional and offending the prohibition against cruel and unusual punishment. Is that a fair summary of what happened?
Yeah. So maybe just to add on to that. So the criminal code has both a possession offense and an accessing offense. And so the sentence of the trial judge was 90 days on one of the offenses for both of them, and then 9 months on the other. Or sorry, I guess maybe one got 90 days and the other got 9 months. And that's how that worked. You're right. And then on appeal, Senville's sentence was upped to 1 year, and I think Naud remained at 9 months. So that the 9 months below the statutory minimum.
Yeah, well, I don't understand what the case is going both ways from out of the Court of Appeal. I mean, either you get a year or you don't. Anyways,
I guess well,
we could get into the
there's all kinds of debates and just in terms of the way that the case was handled, it was very interesting, and I'm leaping probably very far ahead, but the Crown did not challenge the finding or try to save the statutory minimum under Section 1 of the Charter. They didn't argue that at all.
Wow.
So I thought that's interesting. I mean, that's a interesting constitutional issue that gets a little bit ahead of ourselves, but
it does. But I mean, I think the bigger legal issue here is like a lot of people will go, how is that possible? Like, I mean, this, given the nature of the offenses that we outline in this case, how did the lawyers possibly persuade a majority? Now, it was not a unanimous Supreme Court. There is a dissent involved, and the dissent, I think, is on the key issue in terms of the legal analysis of how did they do it? How did the lawyers pitch this argument in the Supreme Court to have them strike down what seems to me to be a fairly reasonable sentence for these types of offenses when you're dealing with offenses against little children? How did they do it? And the way they did it is they put a different set of facts to the court. The court struck the section down not on the facts of Mr. Seville and Mr. Naud, but on a hypothetical. And I think that for our listeners, it's really important to understand the way the argument works. So the courts have allowed lawyers to make arguments to say, here's a section of the act, and we say that it's cruel and unusual because just assume that this happened. And, there's been cases that have come along previously. There was one case, I think it was out of Alberta, where there was a mandatory minimum sentence for the use if you discharged a firearm into a dwelling house.
Right.
And what the lawyers came along and said, well, yeah, okay, so that would apply to, some 18-year-old kid takes a BB gun and shoots a tool shed. And the mandatory minimum was like 2 years. Well, no, everyone goes, no, you don't have to go to jail for 2 years for shooting a BB gun at a tool shed. But that's the way they did it. So what they did here was they came up, you've heard about the kind of horrible aspects of the actual facts here and the nature of the victims. But here, what they did is they came forward and said, look, here's the section. And assume that you're, an 18-year-old who turned 18, let's say his birthday was September 15th. And it's September 10th. And he's dating a girl in his class in high school who is got a birthday, and it's her birthday is September 30th. And so she's 17 and he's 18. And they're in some relationship. And I guess this is something that people do these days. I'm too old to remember that this doesn't happen to me. That's in our day and age, thankfully. But she sends him a naked picture of herself as a 17-year-old to an 18. That technically would be child porn.
Yep.
And
absolutely.
They said, do you really want a mandatory minimum where on those facts, the 18-year-old goes to jail for a year? And on those facts, I go, well, of course not. No, that doesn't sound, no one should go to jail for a year for that. And that's how they did it. What they did was they took hypothetical facts and not the facts of the case. And that, that's how they did it. Now, that was the issue, as I understand it, where the minority and the majority parted company, because the minority said, no, that is apples and oranges. You can't possibly use that as a hypothetical that correlates to the facts of this case. And I have to say that I find to be extremely compelling, because to me, those are very different.
Well, and it's a great tool for education, right? In terms of how lawyers and how the law has these different tests and these different principles, and how they're argued and applied, and what judges will and will not accept. And so it does. It turns on the hypotheticals, which actually both parties agreed to put before the court, right? The prosecutor and the lawyers for the accused. Okay, here's the hypothetical, right? Prosecutors agreed to use these hypotheticals and said that they were appropriate. And there's a body of law that the majority clinged to that said, yes, we can use this hypothetical. It's appropriate. And based on the 17-year-old and her photo to the 18-year-old male accessing it a couple of times and receiving it,
The new love letter.
yeah, it's a disproportionate sentence to what the mandatory minimum would be.
Sure, because everyone can see that obviously, I mean, they're not two consenting adults, but they're pretty close.
Right. And so now what you've got the minority looking at this. And remember, I think the foundation is that child pornography is abhorrent. It needs to be eliminated as much as possible. And they say that the hypothetical is too remote. And they rely on cases that make that suggestion over time, that the 18-year-old with the 17-year-old girl is so far away from Seville and Naud, who had hundreds of images
Of 3-year-olds.
Of 3-year-olds, like toddlers.
That's what I think is the problem.
Right?
That's like why I say that there's a fundamental difference between a 17-year-old's ability to consent,
right,
and a 3. I mean, this whole notion that that all of a sudden the light bulb goes on when you turn 18 and you're a sentient human being, where the day before you weren't. It's just it's so arbitrary and artificial. But no 3-year-old is consenting to anything. They're not capable.
They're not capable of consenting to it.
Exactly. And they are innocent, truly.
And then it's disgusting anyway, even if they were to consent to it. It's like,
no, but I mean, look, that's not here. We have our to quote the case, our normative view on that. I agree with you. It's like, it's more like, what is wrong with like what kind of, like, anyways, we could, but I mean, it's not for us to cast judgment on what two consenting adults decide to do. It's not for me to say. And nor I think is it, and for the most part, is it for society to say. But it's a completely different situation. So the whole concept of two consenting adults is antithetical to child pornography, because you don't have two consenting adults. You have a predator and prey. And the prey does not consent to be preyed upon. It has no ability to do so. And it is not consenting to anything. And it's not an adult. So to me, the hypothetical really is a square peg in a round hole in this particular instance.
And I think, and that drives the view of the minority, that those hypotheticals are just too far-fetched from the circumstances, that you actually have to look at it in the context of the people who were charged and what the real offense was for the hypothetical to be appropriate. But their view did not rule the day. And so what we have is a 5-4 decision that the 1-year minimum is unconstitutional, because it constitutes cruel and unusual punishment under Section 12 of the Charter. And immediately upon that announcement of that decision, people are freaking out politically.
Yeah, no, and I mean,
understandably so, right?
Well, it became an immediate political platform for the opposition to suggest that they would have invoked the notwithstanding clause to maintain it. Now, I do have to say that, coming back on that point, as abhorrent as the facts of this case, the real facts are, There is value in the hypothetical because what it does is it reveals to me a great um, problem with the drafting of the legislation.
Exactly.
That is, I'm able to put forward a scenario that no one would think is appropriate. I mean, I don't think any rational person would agree that a year in jail for the 18-year-old in that fact scenario is appropriate. It's just not appropriate. I suspect that the number one person screaming and yelling that it's not appropriate would be a 17-year-old girlfriend. So, that to me it shows there's a weakness in the legislation. There's a weakness underlying the way these sort of black and white, cut and dry mandatory minimum sentences are. And I mean, I think, as much as I want to come back to the point that mandatory minimums would not be necessary if judges imposed sentences that actually fit the crime. And I don't think that in this instance, my own personal view is 90 days does not fit the crime for this case. If the judges imposed realistic they wouldn't need mandatory minimum sentences. There would be no need for it because they would impose appropriate sentences in every case. But there are judges and they have discretion and they exercise it in different ways. And that's they're entitled to do for the most part. But from my perspective, it's revealed a significant weakness in the way this legislation is drafted. And maybe the legislature needs to go back to the drawing board and put in what is in reality the case, which is to say that there's a big difference between a 17-year-old who's 2 days shy of her 18th birthday and a 3-year-old. Um, a big difference. And maybe the legislation needs to recognize that and give discretion at a certain point, but not at a certain point. 3-year-olds, no discretion.
Well, look, I mean, I don't disagree with you. I like that's the problem with the way that the provisions were drafted is that it applied to everybody.
Right.
And so, yes, you could use, I suppose, the notwithstanding clause as the easy way to not amend the legislation, or you could do it, I guess, the more thoughtful way and actually draft legislation that makes sense and that distinguishes between certain circumstances so that you can carve out,
And avoid the outrage that would inevitably occur
exactly,
when you've
right.
got the 18-year-old going in the clink for a year for in that fact scenario, which is equally unjust as much as I think the sentences in this particular case were also unjust. So
Well, look, I mean, I don't think anybody's really concentrated on whether the 1 year sentence in the cases of these two was too low anyway.
that's the big issue for me because I think you don't need mandatory minimums are a great political saw for sort of law and order uh, political platforms if that's the platform a politician wants to run on but they only are necessary if the judiciary is not imposing sentences that are deemed by the public to be appropriate for the crimes if they are a reaction to what is perceived as soft sentencing. So in this instance it's mind-boggling to me that the someone with that amount of material involving 3-year-olds is getting 90 days. What? Like,
it just
that's
doesn't make a heck of a lot of
outrageous.
sense, right? So, but again, and again, that seems to be a little bit of a distinction between the majority of the court at the Supreme Court of Canada and the minority
No, because
opinion
I
is
think in
that
the I think in the facts of this case, I see both sides of it. Because I think in the facts of this case, I agree with the minority that the hypothetical that was used is not helpful in terms of in terms of this
right,
case because it's a completely different situation. I think the legislation allowed for it because it's weakly drafted legislation that was too much of a one size fits all piece. Needs to have a little bit more nuance in it to prevent both evils. The soft sentencing of child pornographers on the one hand, and B, the too harsh sentencing of people that are caught sort of in this one size fits all hopper of legislation. So legislatures need to tailor the legislation in some ways to fit both, to avoid both evils.
Right, but the minority of the court was also looking at sentencing principles, and that for child pornography, denunciation and deterrence are the two most important factors
Right.
because of the seriousness of this kind of an offense. So, that also kind of drives the minority to say, well, hang on a second here. This hypothetical makes no sense.
Yeah, no, it doesn't. Because I think you just look at the nature of the victim, and the victim are so different as far as I'm concerned, that the victim in the hypothetical, if they consider themselves to be a victim at all, is so completely different than the nature of the victim in the facts of the case. And that's what
Well,
really drives my frustration with it.
well, yeah, look, for those listeners who have been around people who have been subject to child pornography, there are scars that are left regardless of the age of the victim. So I gotta tell you, I kind of sit there with the minority, and I'm compelled by the minority argument more than I am by the majority's argument.
Well, look, I think
So,
the easy knee-jerk reaction would be to jump to the notwithstanding clause. It's tempting, and this type of an offense is so incendiary that it's probably good politics to do that. But I actually think in this instance that the hypothetical, as much as I dislike the outcome in the particular case, I think the hypothetical is helpful because it reveals flaws in the drafting of the legislation.
of course.
And it shouldn't be saved by the notwithstanding clause because it's bad legislation. And it's up to the legislature to get on their hobby horse and redraft it.
Yeah, but it'll make the criminal code heavier and heavier and turn it into the tax code.
Well, if that's the worst case scenario, then that's the way it goes. It's I think this is one of those cases that it's one of these cases where we're going to be hearing more about this case, I think, in terms of politics, because it's going to be spun in all sorts of ways. And no one wants to be on the side of the child pornographers politically, I would assume. So I think more to come in terms of what the legislature is going to do. I know that the federal Liberals will not countenance the notwithstanding clause, but it may become an election issue when we have another election. And who knows when that will be?
Who knows? With people crossing the floor and doing all kinds of things, we may not get one very soon. I don't know.
We often say here that American politics is so interesting. I don't know anymore. I think that Canadian politics is getting pretty interesting. Follow the bouncing MP as they jump across the aisle. Interesting days indeed. And who's got the majority? Well, we'll soon find out when the pieces stop moving on the board.
Bouncing MPs are certainly not above the law.
And just remember, if no one is above the law, including bouncing MPs and child pornographers, then everyone is beneath it. Thank you for listening, Stephen, and look forward to talking to you next time.